Members, we turn now to the Electronic Monitoring of Offenders legislation bill. The question is that Part 1AA stand part.
Mr Chair.
I call the Honourable Paula Bennett.
Mr Chair, I seek leave for all provisions to be taken as one question.
Leave is put for that purpose. Is there any objection? There appears to be none. I call Kelvin Davis.
Thank you, Mr Chair. The Labour Party supports the Electronic Monitoring of Offenders legislation bill. We support this bill because it should protect New Zealanders from criminals who have been released from a sentence of 2 years or less or sentenced to intensive supervision. It amends the Parole Act of 2002 and the Sentencing Act of also of 2002. Mr Chair, the intensive supervision, it's a community-based rehabilitation sentence. It targets offenders who are of medium to high risk of reoffending. They've been convicted of more serious type crimes. They've got complex or severe rehabilitative needs, and intensive supervision can only be imposed by a judge. That's why it's important that these people, when they are released into the community, they do have electronic monitoring, i.e. a bracelet attached to their ankle, or, so that their movements can be tracked. The big thing though, Mr Speaker, and we've got to get it out there right at the very, Mr Chair, we've got to get it right at the very start, is the fact that these electronic monitoring bracelets are only as good as the quality of the materials that they're made of. And we've seen so many cases where electronic monitoring bracelets have been cut off. And in fact, there was the infamous story where a TV cameraman cut them off with a pair of scissors. Now, apparently there's only about 1% of offenders at any given time who have cut off their bracelets, but earlier this year that 1% equated to some 47 offenders. And it's easy for us to say, look, let's not get too worried about it. 1% is not that great a proportion, but when we say 47, that means there's 40. When we say there's 47 offenders who have cut off their bracelets, that's 47 communities, 47 suburbs, 47 towns that are living with some element of fear because we have these offenders out on the loose. So it is important that we get this right, that the electronic monitoring bracelets are made of robust, sturdy material, and they can't just be cut off with a standard pair of scissors. I believe there's going to be even sturdier material that these bracelets are going to be made out of. Well, the big thing is that sturdier material just requires a bit of a sturdier implement to cut them off, such as bolt cutters or tin snips. So it's really important that they are very robust. The reasons why there has to be some element of or some ease to have them cut off is for health and safety reasons, in case these offenders happen to be in a car accident and they have to be x-rayed, and the equipment may affect the x-ray or the medical machines and the scanners or whatever the hospital uses to check up on the health of these people. So I was thinking about what could be a decent system of robust bracelets, and when I was thinking about how if you go shopping and you buy some clothes and they've got those tags on them, those tags that set off a buzzer if you walk out of the shop with them on, and that there's a special device used to remove those tags. Maybe that's the solution, that whatever bracelet is made is of such sturdy stuff that the emergency rooms and that in hospitals actually have a box full of these little gadgets that can remove the bracelets if they need to be removed. Mr Speaker, in terms of Part 1AA, it amends the Corrections Act, and it mainly deals with those people who are on temporary release from prison. Temporary release is when somebody is let out maybe on compassionate leave, such as for a funeral. And in fact, last Thursday I was contacted by the family of a woman who had passed away. Her daughter was ringing me to see what I could do in order to get her brother out of prison and a couple of nephews. So the grandsons and the son of this particular woman were in prison. Now, it's quite interesting that the two grandsons were fairly low risk prisoners in Spring Hill, and the son of this woman, actually, Mr. Chair,
Kelvin Davis.
the son of this woman was in prison for manslaughter and was considered fairly high risk. What's strange about this temporary release is the guy that was fairly high risk was actually allowed out to the funeral, whereas the two who are low risk in Spring Hill were not allowed out to their grandmother's funeral. So it's just an element of inconsistency there. They were in two different prisons. The two younger guys were in Spring Hill and the older guy was in Pāremoremo. But there was a classic example of when an offender may be entitled under temporary release, Mr. Chair, which is what Part 1AA is about, to have to submit to wearing of the monitoring bracelet. And the purposes of the monitoring bracelet in this case, and in fact in all the other parts as well, are firstly a deterrent effect. If an offender is wearing a bracelet, the belief is it will deter the offender from running off and breaching the conditions that relate to his or her whereabouts, but it's also to monitor compliance with the conditions that relate to their whereabouts. The bracelet itself can be used to verify compliance with any of the conditions, the whereabouts of the offender, and to detect non-compliance. It's also can be used to provide evidence, which I am assuming would be evidence later on, to say, yes, that person was meant to be in a restricted area and has gone out and breached the condition of where they should have been. But also, it could be that if there was a criminal act committed somewhere in the vicinity, and you'd be able to either confirm or eliminate the fact that that offender may have been in the vicinity or at that particular place at the time the offence was committed. So it can be used, the information from the electronic monitoring bracelet could be used to provide evidence at a later date. So it can also be used to verify that the bracelet hasn't been tampered with, because if the bracelet has been tampered with again, the offender will have breached a condition of the of wearing the electronic monitoring. So Part 1AA is about temporary release. People can be temporarily released just outside of prison limits. When I say around the prison limits, I mean outside the secure perimeter of the prison. So there may be reasons for where prisoners are allowed to do work outside, and there's actually, I believe, self-care units around prisons, but they're not within the secure perimeter area. So offenders may be, may be compelled to wear these bracelets to make sure that if they're in a self-care unit outside the secure area of a perimeter, that they wear the bracelet so that, if they do disappear, A, they can be tracked, or B, make sure that they haven't disappeared when they should have been inside the area. So that's Part 1AA. Part 1 itself it amends the Parole Act of 2002 and is about people who have obviously been paroled, whereas Part 1AA was about people just who are prisoners but on temporary release from the prison. The same sorts of conditions apply for the people who are on parole. They may be required to have electronic monitoring equipment attached to them. And that's actually a part of the bill, is that it changes, it changes the law so that it makes it explicit that people might have to have these electronic monitoring bracelets attached to them, whereas previously I don't think it was quite so explicit. But again, it's part one is about the offenders on parole and
The Honourable Phil Goff.
I want to first say that the